case filed on the 17th of February. My lords, it is our respectful view that this application does not appropriately invoke the special review jurisdiction of the court under Article 133, as well as Rule 54 of CI 16. Lords, we are submitting to this honorable court that this application is a classic case of an aggrieved party who has become emotional by the decision of the court, seeks to re-argue his case through the back door of an apparently review application, which it is not. And for these reasons, my lords, the application ought to be dismissed. But we would like to make a few other points. My lords, counsel has referred to Section 26 of the Evidence Act. And whenever he does so, he fails to recognize that that section is subject to any other law or rules of equity. And my lords, in our view, under 38, Rule 3E is any other law. So this is not a situation where you can argue that you are using a subsidiary legislation to trump a substantive legislation. Because if one goes to Article 11 of the Constitution, it defines the laws of Ghana, it includes subsidiary legislation. Now, Lords, again, the petitioner cannot seek refuge, even if it is true, in the fact that the application was argued not on grounds 38. Why? Because before the court, there was extensive argument on that order. 38 rule. Sorry, that 38. There was extensive argument on both sides, including questions by the bench. So it does not lie in his mouth now, after the fact, to suggest he couldn't be suggesting that he was taken by surprise. He had every opportunity to advance his arguments. We also advanced our arguments, showing how circular his arguments were and how completely misconstrued his attempt at interpreting the various sub-rules under Order 38 Rule 3E was. So, my lords, it is our submission that this court is entitled to ignore all the arguments that have been advanced today in respect of the correctness or otherwise of the use of Order 38 Rule 3E. Then again, my lords, we do not see the relevance whatsoever of a reference here to Article 19.3 of the Constitution, which is a criminal matter, deals with criminal matters, and also Article 296. My lords?
Actually, I did not refer to Article 19.3. I referred to Article 19.13.
Very well. sorry. My lords, my other point here is that now a major foundation of this application is the interest of justice. My lords, we all know that when courts rule based on the interest of justice, it's not at large. It is in reference to the specific circumstances of each case. So, my lords, it cannot be that the interest of justice is a ratio. I mean, it cannot be.
After connecting clause 30.
No, I'm not from that.
Yeah, okay. Yeah, carry on.
I'm saying that one cannot use the interest of justice as declared by a court in a particular case as a general magic wand. You know, any case, you say that, in that case, by the interest of justice, which was the ratio, should apply there. It cannot be so. Every articulation of a decision based on the interest of justice is grounded on the specific facts as assessed by that particular court. And this court, or the ordinary bench, had assessed the facts of this case and did not find that there was any compelling interest of justice for it to grant the application being sought. And my lords, this is so, in my view, respectfully, because this whole case is based on the fiction. It's based on the fiction. No, the whole case, under which this is a subset. Yes, the petition. It's all based on the fiction.
At the tail end of your...
No, that's not relevant.
No, please, we are dealing with this application for review.
But the application for
he has argued at length. We have spent time for him, so take your time. Don't go to the substantive matter. Yes, we are giving a ruling and they are seeking a review. Yes.
So, my lords, I believe and we submit that this application is completely unmeritorious and does not satisfy the very strict conditions for review laid out in Article 133 of the Constitution and Rule 54 of this court's rules. We accordingly pray that this application be dismissed as an abuse of court process. And even though we are all aware that in constitutional matters like this, no costs are awarded, I think this is a proper occasion.
Is this a constitutional matter?
Yes, this, more or less. It's a special jurisdiction under the Constitution, yes. So, and if it isn't, more so, why costs should be awarded.
And Mr. Akoto, I'm interested in why you permitted Mr. Akoto to swear, to depose to the affidavit in opposition on behalf of the second respondent when he is not on record as the attorney for the second respondent. What we have on record is that Mr. Akoto is one of the counsel announced in this case. Is there any justification why?
Yes, my lords. The attorney has powers to testify.
there are factual matters that has been deposed to. We have been told that one Peter McMenu is the attorney for the second respondent. Well, from this practice where lawyers who are engaged by parties take it upon themselves to depose to affidavit when the parties are there. Can you justify it?
My lords, as I've indicated, lawyers take instructions from their client. Our client is the second respondent. Mr. McMenu was given a power of attorney to go into the witness box if necessary to testify.